You were charged with unlawful carrying of a weapon. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On February 9th, 2025, the officer was dispatched to an assist the officer call in regards to a shots fired at 1700 Travis Street. The defendant was detained because the officer observed an unidentified individual discharge a firearm, and the defendant was within that group of people. The defendant admitted to the officer that he had 2 ecstasy pills in his right front pocket and that there was an AR pistol in the SUV the defendant was driving.
Yikes, we've got drugs and an AR pistol in the same traffic stop. And here's the legal twist. He admits he knew the weapon was there, but he didn't say it was his. In court, that small difference can make or break a case. So what do you think? Should knowledge alone be enough to charge someone with possession? Let me know below.
The officer completed a search of the defendant and located 2 methamphetamine pills in his front right pocket, and the defendant informed the officer that he was aware of the AR pistol in the SUV prior to him getting behind the wheel. The officer located the AR pistol on the floor in the second row of the SUV within reach of the driver. The substance was believed to be methamphetamine based on training experience with a weight of 0.61 grams.
Husband, I'm going to find that there's probable cause. Wait a second. He says that the AR is his?
He says he was aware that it was in the vehicle and it was within his reach in the vehicle.
Whose vehicle is it?
I don't believe it says in the DMs, it says he was driving the vehicle.
How do you put it on him?
Allow me to read the full DMs, Your Honor. Yes, Your Honor. It says that he was driving, so it would be that he was in care custody control because he was operating the vehicle with knowledge that the firearm was in there and it was within his reach, his ability to grab the firearm.
Diego Camacho?
Not. How do we know that it was in there while he was driving? How do we know that they didn't put it in there after the fact?
The defendant stated that he was aware that the AR pistol was in the vehicle before he got into the driver's seat, before he started driving.
Oh, no. It just said that he was aware.
Okay.
Don't add stuff in.
I'll read the complete DIM.
Read it.
It says the DIM states completely that the defendant informed the affiant, the officer, he was aware the AR pistol was in the SUV prior to him getting behind the wheel, and the defendant informed the officer that the AR pistol could be found in the SUV at the time of his arrest.
This is classic courtroom chess. The defense is trying to poke holes. When exactly was he driving? Who really owns the car? But the prosecution holds strong if he had control of the vehicle and knew about the gun. That's enough for probable cause. This is where legal nuance gets real.
Are we to assume that it's his? All he says that he knew that it was in there. It's not his car.
In Your Honor, just as cited, the pleading is that it was on or about his person. So we're just saying he was in his possession because it was in the vehicle he was operating with knowledge that the AR was in the vehicle as well as it being within arm's reach.
Do you even know when he was operating the vehicle?
I apologize. What do you mean when he was operating?
Was he operating it in the morning, in the afternoon, at 9 o'clock at night? When did all this transpire? What time of day is this?
Let me see, Your Honor, because based on the DIMs that I see, it appears that
there's a group of people.
It appears that the defendant was, according to the DIMs, the defendant was found to be at the wheel of a black GMC. So when the officer arrived, he was observed within the vehicle, from what the officer says.
Was in the car at the time the cops get there.
From what the officer says, that he was observed behind the wheel of the vehicle. To be at the wheel of the black GMC Suburban bearing a license plate number that is in the DIM.
Okay. All right. Husband, I'm going to find that there's probable cause to go forward with your case. I mean, we take it seriously. I want to make sure if there's enough probable cause that's. So I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand? If I find that you're a danger to my public, I only have one place for you. So don't. That includes everything. Do you understand, Mr. Husband? Do you mind filing no weapons, please?
Yes, Judge.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're ducking, you're dodging, you pick up a new case, it's not going to go well for you. Do you understand? All right. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the juror box and get your bond conditions. We'll have you sign it, and then you're free to go. All right.
Yes.
Mr. Williams, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Okay, now, this got heavy. A domestic violence case, and the defendant admits to losing control. The judge isn't holding back either. No contact, no weapons, no second chances. How do you feel about this zero-tolerance stance? Drop your thoughts, but keep it respectful. These are real people, real consequences.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 8th, 2025, the officers were dispatched to a disturbance call. The officer met with the complainant, who stated that she and the defendant were in a 7-month relationship. The complainant stated that she shoved the defendant with her shoulder and that the defendant then grabbed her and threw her around. The complainant advised that the defendant was grabbing her face and neck area and has pushed her to the ground, causing pain. The officer observed a laceration on the complainant's hand and a swollen lip. The officer made contact with the defendant, who stated that he lost control and that he admitted to shoving the complainant.
Williams, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand? If you have contact with this person, if I find that you're in possession of a weapon, I'm going to revoke your bond, put you in jail. No more PR bonds. I want my community safe. I don't care who it is, what color they are, whether they're a small farm animal. I don't care. Everyone gets protected. Do you understand? Do you have the ability to hire a lawyer, Mr. Williams? Okay. I will take a look at an affidavit. I'll see whether you qualify, and then I'll have you take a seat in the jury box. I'll have you sign a reset with Victoria now. Do not leave until you sign our bond conditions. Do you understand? And then I'll have you talk to a lawyer here momentarily.
I work with her, so
I'm sorry?
she worked at the same
That's going to be an issue. I don't want you to have contact with her. Actions have consequences.